really excited to be here with you guys. This is, of course, the Friday of Denver Startup Week. I am from Milgram and Daskin. My name is John Milgram. We are a boutique law firm based here in Denver, 17 attorneys. We work coast to coast with B Corp, or 1% for the planet, a little bit different than your traditional law firm. We can handle pretty much anything that a business needs. I personally focus on working with startups. And I won't talk too much about our law firm, but check us out if you're interested. This is the third of 3 sessions that we've put together, and many of our attorneys have presented. I don't know if any of you have made it to the other ones. The first, well, I'll get to that. I'm supposed to thank our fantastic partners here, our sponsors, Amazon, Capital One, Cafe, Dell, and of course the great design and track sponsors, Public Works and Battery 621. Thank you all for letting us be here. This is our 5th year presenting at Denver Startup Week, and it's a really cool event. I'm sure you guys are all enjoying it, and I'm very grateful to our sponsors for making this a possibility. More sponsors, they're all great. So, I'm going to be talking to you about putting IP into hip, and as you can tell from my thick rim classes, I'm very hip. We're going to be talking a lot about IP. Everybody's interests in this room are going to be probably slightly different, so I'm going to do a fairly broad overview of IP, and then we can dive into more specific questions, and I want to make sure this is as valuable for you all as possible. Before we dive into the nitty-gritty here, I have to issue a disclaimer that I am not your attorney. There is no attorney-client privilege here. In addition to that, anything that I say is for informational purposes. It is not legal advice, yada, yada, yada. Happy to talk on anything you guys want to talk about. As I mentioned, this is the third of 3 considerations. So when I work with startups, I think about 3 buckets. I think about your entity formation, structure, and finance. So the first thing you need to do, which was our first presentation, is make sure you have an entity, make sure you're protected, understand what the money coming in is. Second thing, third-party contracts. 2 and 3 really go together because your third-party contracts will dictate a lot of your intellectual property rights. That was a session that we had earlier on Wednesday. And then today, we're wrapping up with intellectual property. So why is IP important to you? Approximately 1/3 of the value of all manufactured products is intangible capital. That was in 2017. So you can only imagine how this has increased. I gave a presentation yesterday on NFTs. That is a $46 billion market currently. And that is basically entirely intellectual property. This is only going to increase. You no longer own your music, you license it. You have Spotify on your phone. There is quite a lot wrapped up in this. In addition, there's a morality issue here. When somebody takes your stuff, it feels bad. It's insulting. It's not fun. So having that protection is both good in terms of business, and it's good in terms of your morality. We can talk about a couple examples of folks who have either leveraged IP in a very meaningful way or who have not done such a great job. So Qualcomm. Every one of you guys has Qualcomm technology probably on your person today. You might not know it, but it's embedded in your phone. They don't actually make anything. They make ideas, and they license those ideas by licensing patents. And it is a billion-dollar company. So it's very clearly something that has a lot of weight to it. TiVo. TiVo is another interesting example. They had a lot of patents. How many of you guys remember TiVo? Doesn't exist anymore. They had a very robust patent portfolio, and now we all have DVR on our TVs. We can click record on YouTube TV or on Hulu. They did not enforce these patent rights because they wanted to be simpatico with a lot of like the time-shifting type companies. And as a result, they slept on those rights, they lost them, and now it went from being a very successful, productive company to one that is not. It's sort of an afterthought. Modern Market. Modern Market was Mod Market not too long ago. There's one on 16th Street over here. They got sued by Mod Pizza because they didn't protect their trademark at the onset of their business. It cost them upwards of $100 million to rebrand, rewrap all their vehicles, change all their signage, just to go from Mod Market to Modern Market. This is something that probably could have been taken care of on the front end for a couple $1,000. So getting out in front of these things is really important. Spotify, as I mentioned, you're licensing all your music. Spotify's done a great job with clearing copyright, but at times they haven't always been as diligent as they should. They were sued once for $46 million as a result of copyright infringement. So aligning your IP strategy is good business. In addition, I know there's some business students here in the crowd today. Having a robust patent portfolio helps you at exit. Excuse me, having a robust IP portfolio. So your trademarks, your copyrights, your patents. When you are selling your business, you'll essentially have a disclosure schedule in whatever agreement it is, whether it's a stock purchase agreement or an asset purchase agreement. And you're going to list out all of your IP there. Having registrations shows that you've taken IP seriously, and it increases the value of your company. So even if you're not going to be enforcing your IP rights, having those IP rights is going to make your company more valuable. So today, we're going to be talking about internal protections, patent and trade secret, and then we're going to talk about external protections, trademark and copyright. So your internal protections are really protecting your crown jewels, so to speak, the things that you hold dear to your company. Your external protections are protecting your identity and the things that you're going to distribute. By the end of this presentation, the attendees will be able to describe the 4 types of IP, analyze your own intellectual property and uses of others' IP for potential risks. Oh, and also, I'll save time at the end for questions. I want to make sure this is really valuable for you guys. We can go in any number of different directions. So, no holds barred, anything's fair game. So first we'll talk about inward-facing IP. We'll talk about patent and trade secret. Patent. Patent is for novel inventions that are reduced to practice. This is important. It can't be an abstract idea. It has to be something that you can actually make or have a high likelihood of making. So I can't just go and patent a time travel machine because this is a figment of my imagination. I think it'd be really cool. I have to actually be able to make it. And when I make it, in my patent application, I'm going to describe how to make it. So the point is to incentivize people to invent things, then that they publish it, but they're allowed to protect it for 20 years. And after that 20-year period, it's fair game. Anybody can use it. So, it does require a registration. It is a negative right to a limited monopoly. So, when I say negative right, you don't actually have to use it. You can have a patent that you just use to prevent other people from using their patents. I don't know how many of you guys followed the Theranos proceedings. This came up in that. Somebody filed essentially a blocking patent, and it was a subject of huge litigation. But it's kind of nice because it favors the little guy in some ways, but it can be a pain in the butt because you have what are pejoratively called patent trolls who are just kind of buying up patent portfolios and trying to prevent people from doing things unless they pay them a bunch of money. So you don't need to use it, but you do need to disclose it. You're going to publish all this information. It's going to be publicly available. It's going to be searchable on databases like Google Patent. This is a really valuable tool for things that are likely to be able to be reverse engineered and also likely to become obsolete. So my phone is definitely not the same phone I was using 20 years ago. The patent protection on that was very valuable, and now it's probably not so valuable because what I was using 20 years ago is no longer in effect. So you look at technology, you look at pharmaceuticals. They're constantly evolving pharmaceuticals. They're also easy to reverse engineer. You could take it apart, you could say this is exactly what's in this medicine, I can remake this. Technology I mentioned before, the VCR obviously is no longer being used, but 20 years ago that was all the rage. Maybe more than that, I don't know, dating myself here. But so, patent is very valuable for items where you're going to protect it with a limited monopoly that likely can be reverse engineered. Patent is very involved. There's a multi-year registration process. You typically start by filing what's called a provisional patent, which is essentially explaining your idea. You might not have reduced it to practice yet. That provisional patent remains confidential, and it kind of plants your flag as this is my priority date. You have 1 year from filing a provisional patent to file a non-provisional patent. What's protected in that patent will be what is stated in the claims of the patent. I wish I'd put some up here, but we can get further into that to the extent that folks are super interested. But like I said, it's really applicable for tech that will evolve or will become obsolete. Now, I used to work for the Office of Tech Transfer at CU. There's a lot of professors there who are creating new medicines and medical interventions. One thing that is really critical about patent that a lot of folks don't understand is if you disclose your idea publicly, you can very well be blowing your right to patent that subject matter. So in the context of the Tech Transfer Office, you have these phenomenal, brilliant professors who are developing a cancer intervention. And they go and publish that in the American Journal of Medicine. You just disclosed that. So in America, you have 6 months after a public disclosure to file for a patent. There's a 6-month grace period. But in much of the world, there's 0 grace period. And it was kind of tragic to see what would happen when these professors would publish their research, because now a drug company is very unlikely to actually pick up that intervention, because the FDA process for approving a medicine is lengthy. So if you apply for a patent and then it takes 15 years or 10 years for the FDA to approve the medicine, you only have 10 years of exclusive use before the generics are going to come out and steal all the market. So if you've blown your ability to patent your medicine or your idea, you very easily could have just sunk that intervention. And we've seen that happen with a bunch of therapeutics, which is really sad, because these are potentially life-saving interventions that then just get buried because there's no way to monetize them. So disclosure can be fatal. You need to keep your invention secret until the time that you filed your provisional patent, and ideally until the time you filed your non-provisional patent. And this means, have NDAs. This is, like I said before, this relates a lot to third-party contracts. Have NDAs with all of your producers. Have NDAs with people developing these items. The other thing you'll need is assignments of intellectual property rights. So this is patent sort of broadly. Protects your ideas, but you can't reverse engineer it. It can be costly. Disclosure is definitely an issue. Trade secret is the other way to kind of protect those internal processes and secret items that are relevant to your company. So a trade secret is information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent value from not being generally known and is the subject of efforts that are reasonable under the circumstances to maintain secrecy. A whole lot of words there, a whole lot of coffee here. Best examples of trade secret, you guys may have heard of the Coca-Cola example, where apparently nobody actually knows the entire recipe for Coca-Cola. Different people in the company know different portions of how it's composed, but nobody knows the whole thing. It's kept under lock and key. This has remained secret for over 100 years at this point. All of the employees who work on it sign NDAs, and it's been fairly valuable. Same is true of Bush's beans. So these are for items that cannot be really easily reverse engineered. You couldn't take Bush's beans and say, oh yeah, there's a little bit of honey in here, and some. You could do it kind of generally, but not the exact formula, the exact recipe. Unlike a VCR that you could take apart and say, here's the circuit board, I'm not a tech guy, but different parts. Trade secret, unlike patent, will last for as long as this remains a secret. Like I said, Coca-Cola has been secret for over 100 years, whereas patent is only going to last for 20. So if your technology is not easy to reverse engineer, and it's not likely to become obsolete, I shouldn't say technology, if your item is not easy to reverse engineer, not likely to become obsolete, then trade secret might be a better protective scheme because you don't have to publish that recipe or that technique or process and make it public after 20 years. As I mentioned, there is the protection that you'll receive is proportional to the protection that you apply. So we work with a lot of breweries. We tell our brewers all the time, don't publish the brewing recipe. Keep it on a need-to-know basis, so not every employee needs to know how to make your Juicy Banger IPA. You can have just the people who need to know. Keep things under lock and key. And you don't need to go above and beyond. So there was a case where some competitors took a biplane, this was a seminal case in trade secret, and flew it over their adversaries' production facilities and took a bunch of pictures and then stole their trade secret manufacturing processes. And the court said, it's not reasonable to expect you to cover your entire facility with camouflage tarp or something so that they can't fly over and take a picture. That was a theft of trade secrets. So you need to have reasonable protections to maintain your trade secret, but they, you don't need to go crazy. I think in this day and age, like password protecting Dropbox folders so that only folks who have a need to know that information can get to it is a really good idea. Not just for intellectual property protection, but for general housekeeping too. So, we talked about two types of internal protections, patent and trade secret. Depending on kind of the length of protection, the cost, patent is obviously much more expensive than trade secret. You don't need a lawyer for trade secret. You can just kind of make sure you have good internal processes. Your ability to reverse engineer, obviously patent, you can't reverse engineer because you have this 20-year monopoly and you've published that information anyways. Trade secret, if you can take it apart, your competitor can make it. There's no bar on that. Both require discretion. Patent requires discretion pre-filing. Don't blow your ability to patent your technology because you went to a trade show and you put your thing out there and now it's out, there's a publication, you can't publish it. Don't write an article or do a press release until you have your provisional patent on file. Don't blow your ability to protect your invention. It's frankly sad to see. Trade secret requires discretion forever. You want your employees under NDA, you want your service providers under NDA, you want to make sure there's confidentiality obligations where people are acknowledging that it's a trade secret. Some of the biggest, I used to work at Covidian, now Medtronic, they would have trade secret logs where people actually kept books of trade secrets to acknowledge that these are trade secrets. They had to be locked in the engineers' desks at all times, except when they were working on them, obviously. But these are kind of the two competing regimes for protecting those internal IP portfolios. So consider which might be right for you. Next, we're going to talk about your outward-facing IP. This is stuff that you're disseminating to the public and largely protected by copyright and by trademark. So copyright. Copyright protects creative works fixed in a tangible medium. I see a lot of you guys taking notes right now. Copyright technically applies right now to all the notes that you're writing in your book or on your computer. You are fixing those, they're tangible. The creativity bar is really, really low. The seminal case on this involves phone books and whether arranging them in a certain way is actually copyright protectable and creative. So they say that it's like a limbo stick that an ant could walk under wearing a top hat. So it's made to incentivize creation and provides a limited monopoly like patent. The limited monopoly is super long, thanks a lot to our friends over at Disney who did a lot of lobbying for the DMCA, and you now have 70 years plus the life of the author. So I think Steamboat Willie right now is going into the public domain, but for the most part things are going to be protected for as long as they're valuable. It protects the heart and soul of the creation. So we know of kind of like the big sexy cases like the Robin Thicke and Martin Gaye, Blurred Lines and Gotta Give It Up, or David Bowie and our good friend over here, Ice Ice Baby. These are the things that you read about in the newspaper. And they're often big and sexy, but truthfully more often, it's kind of a pain in the butt. You're not dealing with some big music producers. You're dealing with somebody who took a photo of something and you accidentally took it and now you're getting sued for $150,000. And we'll talk more about that and I'll give you guys some examples. Infringement is related to access and similarity. So we're talking about the heart and soul of the work and I'll talk a little bit more about that on another slide as well. We've also been seeing a lot of trend, and I didn't talk about this as much as I should during patent. A lot of people want to get software patented. That's really tough in this day and age. There were some holdings at the Supreme Court level that basically said applying an abstract idea to software is not patentable. That came out in the context of escrow. So there was a company that created software that was an escrow software where once a few conditions were met, it would release the money. And they said that's not patentable. So what a lot of folks have been militating towards is filing copyright on the computer code. It is a much more limited scope of protection because it's not actually protecting the functionality, it's protecting the fixation of the code itself. But it is something, and it's also accessible and relatively inexpensive. So when you're making your own stuff, you should very much consider registering your works, like copyright and software code that I was just talking about. even though copyright attaches at common law, so right now all of your notes are technically copyright protected, you can't actually do anything about it without a registration. So if you wanted to bring suit for copyright infringement, you absolutely have to have a registration. Like I said, registrations are pretty easy to get. It's currently a $65 fee to file a copyright application, and depending on what you're filing on, you often can file multiple works in one application. So it's pretty low-hanging fruit to get the registration, and frankly, if you're producing a lot of content that is copyrightable, I would strongly recommend getting a system in place where you're constantly kind of rolling out your copyrights. We work with a number of content creators, and we just kind of have them photo dump on us or dump all their blog materials on us once every quarter or so, file all of it, and just get out ahead of it. Because if you have a registration and somebody infringes you, it's actionable, and you're entitled to significant statutory damages. Willful infringement entitles you to damages of up to $150,000 per incidence of infringement. So that can be really, really hefty. So if you're creating the content, you want to make sure you're registering it, make sure you're protecting it. It can take a little while to get a copyright registration, maybe 6 months-ish, I would say. So you want to get out ahead of this before you're getting infringed. If you start getting infringed and then you file a copyright application, you can file with what's called special handling to get your copyright registration more quickly, but then the fee is $800 extra. So now you're paying $865 instead of $65, and the application is also looked at with a significantly greater degree of scrutiny. The only copyright applications I've ever had rejected are ones that we filed under special handling, and to be completely honest with you, it is totally arbitrary as to how they decide what is creative and what's not. For example, we had a special handling application where we could file 10 works in that application. 2 of the works were identical except different colors. One of them was granted registration and one of them was not, because purple is creative and gold is not. I don't know. And you can appeal it, but it's not a very straightforward appeals process. So getting out ahead of things, you're going to get your registrations, you're going to have everything in order. Once again, when you're building out that disclosure schedule, when you're selling your business, you're going to have a large inventory of copyright in that disclosure schedule, which is going to drive up the value of your company. This is honestly just good business. It's relatively inexpensive. So a couple other things. Put a copyright notice on your works. This entitles you to greater damages if somebody does indeed rip it off. That's really easy. You can do that without a registration. So circle C, year, name, and that is notice to everybody else that this is your copyright protected subject matter. Can you save it till the end? Thank you. Incorporating others' works, you need to give appropriate credit. When filing, you need to mention that these folks are involved as well. This is also very much a product of contract. You're going to want to make sure you have all of the work product that is being integrated into your copyrightable subject matter assigned to you or the company. So if you have a third-party developer drafting software for you, you absolutely want to make sure that in that contract there's operative language that it is a work for hire, and in the event that it is not a work for hire, they are assigning all right, title, and interest, the belt and suspenders there. Work for hire only applies to a certain limited category of works, and you want to make sure that you have, if it's challenged that it wasn't a work for hire, that you have that assignment language in place as well. So copyright requires, for infringement of the copyright, there's kind of a sliding scale of access plus similarity. So the more similar a thing is, the lower the access needs to be in order for the courts to deem there to have been infringement. So we're working on a case right now where one of our clients provided software to a business partner, and then they basically went out and changed it a little bit and started selling that same software, which they were definitely not entitled to do under this contract. And so in that situation, access is super, super high. We literally gave them the software. The similarity in that case doesn't need to be as close for there to be infringement. But there's a lot of other cases, particularly in the music world, where like the 1-4-5 chord voicing is available in like every single song ever, and you can go to watch like mashups of 50 different songs that all sound the same. similarity can be really high, but if there was no access, it doesn't really matter. So this came up with the Beatles actually, where some guy was like, I actually wrote this song in my basement before the Beatles released it. And they were like, yeah, but the Beatles would have no way of seeing that. And so if there was completely independent creation and you both came up with the same thing, but there was no access, similarity can be very high, and it's not infringement. As I mentioned, with registration, you get statutory damages. That's really huge. Because otherwise you have to prove what the damages were, which becomes a very expensive battle of experts saying, you know, they took our copyrighted material and it should be worth this much, and the other expert's going to say, no, it's worth nothing. And you're going to end up probably somewhere in the middle. So statutory damages, $150,000 per incidence of willful infringement is a huge portion of your claim.
Does that depend on the state? I understand that some of these statutes, some of the states you can go for the kitchen sink, and others, you know.
So this is federal. The copyright regime
for the damages.
Yeah, for the statutory damages is federal. There would be state claims of action like misappropriation or unfair competition. There's one claim that would be the copyright infringement claim, which would be a federal claim, and that would be the statutory damages you could get. You could get increased damages over that for a lot of state claims as well.
So that patents are different. There's no statutory federal on that, right? So the infringement of a patent depends on the state. Is that correct?
Patents federal as well.
No, I understand that the patent.
The damages.
Yeah, the damages is not federal. There's nothing federal about the
damages. Yeah, would be more context specific for patent.
Thanks.
So we talked about what to do with your own creations. Register them, make sure you've been assigned the rights in the things that you're incorporating into yours. That's really the keys. What do you do when you're working with others? I know we're on the designer track here. I've worked with a lot of developers, folks in the marketing area, where they're taking work from other folks. Be really careful. We've seen a significant uptick in copyright infringement cases being brought, and once again, using the pejorative word trolls, we've seen a lot of copyright trolls. In addition to that, we passed the Case Act relatively recently, which is going to be basically small claims court for copyright infringement that you can get into without a lawyer. So you have incredible access to images now. Every photo that I have here I took from some website. It's super easy to accidentally infringe somebody else's work, and there are a lot of very unscrupulous folks out there who are trying to lure you into this. And I'll share a story of that, actually two, here in a second. So as I mentioned, there's copyright trolls, and they'll do this reverse photo search to see if you've used their work. They're entitled to statutory damages. So this photo here, this good old troll, is a photo under the Creative Commons licenses. So I don't know, how many of you guys know about Creative Commons?
Say that again?
Creative Commons.
Creative Commons?
Yeah. So a Creative Commons license typically entitles you to use a work if you provide appropriate attribution. That appropriate attribution is specified by the author, and you absolutely need to make sure that you're doing that. Because there's a lot of times where they'll put the attribution language in very small print in an area that's not super accessible, and they'll say this is a Creative Commons image. And so then you use it, but you don't quite attribute it correctly, and you've just committed copyright infringement. And then you get a cease and desist letter. And then you have to pay a bunch of money. A real estate agent that we work with here in Colorado put a photo of downtown Denver that was very innocuous on her website, ended up settling for $10,000, which, that was like a probably 30-second decision on her part, just be like, click, paste. In another situation, and this was totally unreasonable, but another instance of why you need to read your contracts and understand your intellectual property rights. We worked with a doctor's practice who had a third party running a blog for them. These gentlemen, I don't even think they ever went to the blog. I don't even think they could have told you the blog address. They had a third party marketing service providing this. They were receiving invoices. The invoice at the bottom said, by paying this invoice, you agree to our standard terms and conditions located at click URL. They didn't know they had a contract. They did. They were paying this invoice over and over and over again for many years. The individual writing their blog took a photo very much like this one. It was related to eye care, and it was a picture of a contact lens case on a counter. Something that you could easily take with your iPhone just sitting there. The blog writer did not have the appropriate license to use that photo. Photo also happened to be possession of a fairly notorious copyright troll. They didn't even send a cease and desist. They just immediately filed a lawsuit for $150,000. The doctors got served, but didn't really think it was real for some reason. And they came to us with like 3 days left before they were about to get a default judgment. They were like, this isn't real, is it? And we're like, no, you're in a lot of trouble right now. We got to get an answer filed on this, or you're going to owe this guy $150,000 for that really innocuous image of a contact lens case, which was only up on your blog, which you don't even know existed, for like 1 or 2 days. So we ended up answering that complaint, and then we went to the blog writing company, and we said, hey, what's the deal? You just used this infringing image. We look at the terms and conditions. The terms and conditions say, we are not responsible for anything we put on your blog. You are solely responsible for anything we put on your blog. So, under the law, we actually would have been liable, our party would have been liable for that $150,000 claim. The way that we negotiated this was we said, look, you guys write these blogs for a lot of people. This is pretty messed up what you just did here. The doctors had no control over this. And if you're gonna insist on going this route, then we're gonna have no choice but to put you on blast and say, like, look at this really unscrupulous company that infringed, and now our doctors are getting, sued out the wazoo. So they ended up stepping in and kind of taking more of an active role in the litigation, which we were able to settle for closer to $25,000. But that's not at all a palatable option for particularly a startup. So you just have to be really, really careful. Read your contracts, understand your IP rights, and make sure that whatever content you're using, you're very confident that you have the right to use it. Because otherwise you can be susceptible to these really significant damages of fairly unscrupulous actors in the space. One more, I thought, kind of funny example. When we started our firm 5 years ago, I had a graphic designer putting together our website. She said, I'd like for you guys to get some headshots that I could put on the website. Great. I know this great photographer. Okay. So she's serving as the intermediary between the photographer and myself. I never actually emailed with the photographer. We get an invoice, and in the small print of the invoice it says, this confers a license on you to use these photos on your website. To which I said, no, we need to have full right and title to this because maybe I want to put it in my Denver Startup Week presentation. Maybe I want to do something else with it. Maybe I want to put it on my LinkedIn page. You're giving me a very limited license to put this on my website. So I sent that to the graphic designer. Graphic designer sends an email to the photographer that says, hey, we want to get this straightened out. He'd like full right, title, and interest to the works. Photographer sends an email back to the graphic designer that says, I do not sell my works outright because copyright infringement suits are very lucrative for me.
Wow.
That was forwarded to me, at which point I said, we're not going with this photographer. So,
He was honest.
yeah. I mean, read your contracts, understand, and if you are a content creator and you're taking pictures of somebody, be fair. I mean, don't be this unscrupulous actor who's trying to make money by hoodwinking somebody. Rely on like the quality of your work product and the fact that you're making good photos, not that you're going to sue somebody for copyright. One more thing which I really want to point out, a lot of folks starting businesses, we see this honestly at least once, twice a month. You have somebody draw your logo. They give it to you, you put it up, great. Maybe you use Fiverr, maybe you use 99 Designs. Without a written assignment, you don't own that. And so you can go and file for trademark protection because it's an indicia of your business. But if the artist who actually created that logo at any point in time says, you can't use that anymore, you can't use that anymore. And so we've had this happen a couple times recently where somebody's friend drew their logo. 4 years later, they're not friends anymore. That's no longer your logo. So make sure when you're getting work done for you, you have that operative work for hire / assignment language in your contract. It can be really brief, but getting that out in front is really important. We had another situation where a gentleman made a bunch of videos for PBS, really cool videos. And the production company, he was just kind of buddy-buddy with, they're doing this, it's about environmentalism, sustainability, they're simpatico, everything's great, we're rah-rah-rah. And then he went to file the copyright, and I said, have you got an assignment? He filed the copyright registration. He said, no, but they'll definitely give it to us. We already talked about it. And then we went back and they said, if you want us to sign the right title and interest, we're gonna charge you an extra $30,000. Okay, so we didn't have that assignment in place in first. We didn't actually have a ownership of that. We have what's called an implied license to use it, and that implied license can be revoked at any time. So you're kind of at the whim of the creator of whatever good that you're using. Unless you get that assignment in place first, you're asking them to sign something that doesn't benefit them. So getting out ahead of that, really important. Fiverr, 99 Designs, other websites like that, in their terms of use, sometimes they'll have assignment language, but more often they say that's between the contractor and the individual contracting with them. So you just gotta be really careful. So copyright is gonna protect tangible works in a fixed medium. Be really careful about getting assignments, be really careful about clearing rights. If you're making your own copyrighted work, register it so you can enforce your rights. And yeah, have fun creating things. Trademark. Trademark is a word, design, trade dress, or sound that indicates the origin of the goods and services to provide consumers with quality assurance. I know when I get a Nike shoe, it's going to be of a certain quality and standard. It is made to protect consumers, so it's very much an outward-facing intellectual property. These are trademarks. Milgram and Dascom, you know you're getting great legal services when you come to us. We're going to have this great logo and tagline. That's our trademark. Denver Startup Week, this is another design or word that is implying that this is the source of the talk you're receiving today. Logos, everybody knows this one? Anybody? There you go.
Death Star.
Exactly. So these are really kind of word and stylized design marks. There's two different categories. You protect both the words, standard character mark, which can protect the words in any format. And stylized design is much more like this logo here, where you know that's AT&T just by looking at it. Can also apply to trade dress. What is that?
Coca-Cola.
That's a Coca-Cola bottle. You know it just by seeing the silhouette. They have protected the trade dress, the look and feel of their product. This expands to a number of different things, including like packaging, obviously this. But like if you walk into a Chipotle and you don't see Chipotle anywhere, you know you're in a Chipotle. They got the corrugated steel. They have the serapes on the wall. They got the sneeze guard. They're all laid out in the same way, and so that is trade dress as well. That's protectable. Christian Louboutin shoes, Bloody Soles. You got your red sole bottoms. That is trade dress. That's protectable. Anything that would provide you an indicia of where that good is coming from can be protected. What are we watching? NBC. Those are the tones G, E, and C for General Electric Company, the parent company of NBC. And that is actually protectable as well. You hear that, you know what you're listening to. You know what you're watching. So the purpose is to assure quality to consumers. It's outward facing. When I hear that tone, I know I'm watching NBC and I'm going to be, I don't know, seeing a show that's on NBC. The gravamen of infringement for trademark is a likelihood of consumer confusion. So I get a lot of questions about like, oh, can I call my product Nike Shoes NYKE? No, you can't. If it's likely to cause consumer confusion, if the consumers are likely to be confused as to the source of the good, you can't do that. So, good rule of thumb, and we'll get to this in another slide, is just always Google your name before you start diving in and investing a bunch of money in it. And it's likely worthwhile to trademark as well, as we talked about with this example with Mod Market and Modern Market, to register your trademark, I should say. And that's a very good segue into this. Trademark, very much like copyright, is a common law regime. So if I set up John's Lemonade Stand on the corner here, I'm developing copyright rights in John's Lemonade Stand right out there as soon as I start using it. However, those rights are limited geographically to where I'm actually using the mark. They're limited to what I'm actually using the mark on. And they may be subject to a senior user's rights. Federal registration confers me much greater rights. It confers me a presumption of seniority throughout the entire United States. expands to the zone of natural expansion. So now I've got lemonade. Well, that probably also covers soda and, I don't know, pretzels maybe? I feel like lemonade stands sell pretzels sometimes. But the natural zone of expansion. You get much greater rights with federal registration. It is significantly in your interest to think about a trademark registration very early on in the course of your business life cycle. As mentioned with Mod Market, probably would have cost them, I don't know, a couple $1,000s to register that mark, and instead they rebranded for over $100 million. So think about this early on, protect your name, you're gonna dump a bunch of time and money into it, make sure that you have the rights in the name that you want to use. Not all marks are created equal. Some marks are more protectable than others. So, there's kind of what's called this spectrum of distinctiveness. The least protection is given to items that are what's called generic. So, for example, there was a restaurant in Boulder which no longer exists, but was called Cafe Food. That is not very protectable. It is a cafe that serves food. It is very much on the generic end of the spectrum. Then there are marks that are descriptive. These are not federally registrable without acquiring what's called secondary meaning. Chapstick. Chapstick, brand chapstick. What is it? It is a stick that helps your lip prevent from being chapped. But they spent a ton of money and hired Peekaboo Street and Lindsey Vonn and put on a whole advertising campaign, and now you see the cursive chapstick and you know that that is a brand. It has acquired secondary meaning. It is now protectable, but before it acquires secondary meaning, it is not protectable. Suggestive marks, these include items like copper tone. They are protectable, and there's kind of a varied line between suggestive and descriptive that we've had to argue a number of times. Arbitrary and fanciful marks, these are the most protectable. Amazon over here. I just learned yesterday, by the way, that the smile goes from A to Z. Pretty interesting. Anyway, Amazon is arbitrary or fanciful. It in no way says this is an online database where you could buy anything. And so that's very, very protectable. It's going to get a lot of protection. So the more protectable your mark, the greater the protection it receives, the more likely you are to receive registration on it. When we are deciding to prosecute a mark, we first conduct what's called a knockout search. This is a very nuanced and refined search of the Patent and Trademark Office database to look for anything that might be confusingly similar. Confusingly similar is applicable to, there's 13 factors they consider, but really the two most important ones are the similarity of the marks and the similarity of the goods and services. So McDonald's for burgers is not likely confusingly similar with McDonald's for hardware. But it would be confusingly similar with McDonald's for sandwiches or McDonald's for tacos. So in this knockout search process, we can kind of develop an idea of what's out there and craft an application so that it doesn't read on another application that already exists. For example, there was a brewery and grill that had the same name as a frozen yogurt stand. And so when we drafted the application for the brewery and grill, we focused a whole lot more in the description of goods and services on beer and beer production than on restaurant and restaurant services. Because restaurant services could read on a frozen yogurt stand, but beer production is a little bit further away. So there's a lot of nuance in kind of the strategy to how you file an application. That knockout search will help you to figure out what your best strategy is. As I mentioned, before you choose a name, if you don't have the money to hire an attorney and do this knockout search, at the very least Google it. At least once a month we have somebody come in who has the name of the thing that clearly already exists. So just Google it and get that out of the way. The test database is where we conduct knockout searches. You can use it as well, and that's a good starting place as well. If you just Google USPTO test, it will bring you to TM search, and that will give you an ability to search some. The searches that we do are much more refined. You can outsource searches as well, but
what was the URL?
It's tmsearch.uspto.gov, I believe. If you just Google USPTO test, that will come up.
It's on the government computer, not Google's.
Yeah, government. This is the government database. And the PTO will only look at marks that have been applied for or registered when they're determining whether your application can register. So they're not looking at common law use at all. They're just looking at the PTO database. Now there are reasons to understand what the common law uses are when you like Google it, for example. There are some big players in the trademark space who are very aggressive in enforcing their trademark rights. Disney, Viacom, FitTech, or iFit, which is like the Nordic track guys. Been adverse to all of these parties multiple times. They just police the register like crazy. And so knowing that they're using a mark, even if they haven't registered it, they very well might be monitoring the Gazette. But the only thing that will block your trademark from registering from the PTO are marks that are actually applied for. If your mark falls more on the generic descriptive side, consider adding more distinctive elements. Distinctive elements are like logos. You're less likely to confuse someone that has a logo or a tagline. Put Subway Eat Fresh on here. Subway sandwich, that's actually relatively descriptive. It is a submarine sandwich, right? So we're going to Subway. So they have this stylized design mark. They added Eat Fresh. You can register all of this. By adding more distinctive components to your mark, you're going to err more to the sides of suggestive, arbitrary, fanciful, and you bear a better likelihood of registering your mark. A lot of times if we have a mark that's kind of questionable, we'll file a series of marks. So we'll file on the name itself, the name with the stylized design, and the name with the stylized design and a logo. And we're just hoping to get one through at the very least. The first registration is far and away the most important. Disclaimers. Disclaimers are a super interesting aspect of trademark. If you have a generic portion of a trademark, you cannot register that portion of the trademark. So let's say I'm registering Applebee's Restaurant and Bar. Restaurant and bar would be disclaimed. I cannot claim ownership of restaurant and bar. It's still part of the mark, and it should be considered in evaluating the mark, but they're going to put significantly less weight on it when reviewing this. And this results in some fairly weird outcomes sometimes. So, for example, we had a mark for taco therapy that was blocked by a mark for wine therapy, because taco and wine were each generic and therefore disclaimed. So they were just comparing therapy and therapy for restaurant and bar services. Now we were able to argue and overcome that, but you can see how this can lead to some fairly interesting situations. I was thinking earlier today about Buffalo Wild Wings. Buffalo Wings is obviously a generic term for buffalo wings. So really they're protecting as wild, which is fairly interesting. But just an interesting aspect where you have to disclaim the generic or otherwise descriptive portions of the mark. So we just went over 30,000 feet, quite a lot about IP. We talked about patent, which is a limited 20-year monopoly to ideas. You cannot reverse engineer that. There's protection there. We talked about trade secret, unlimited use as long as it remains a secret, but third parties can reverse engineer it and use it that way. We talked about external protections, copyright and trademark. Copyright, be careful of traps, protect yourself, register your works, make sure you're getting assignments. And trademark, the origin of the goods and services. Search for your mark before you name your company. Register, don't be modern market. Make sure you get that taken care of on the front end. And then as I mentioned, as you're building your patent or your IP portfolio, it's going to drive value both in your enforcement, in your ability to protect your special kind of value proposition, and then if you do move to sell your company, being able to show that you've taken your IP seriously, being able to show that you have a portfolio of intellectual property protections is going to drive up the value. I am John Milgram. That is my email address. Slides will be posted on milgramlaw.com if you guys are interested. That is Doug Mack, important nerd computer there. And with that, I will take any questions. Becca.
You go first.
Thank you.
Okay.
So for the copywriting, when you submit blogs on your website and you have the generic one on your website, does that cover all of the articles and things like that, or do you need a separate one on the individual blog posts and articles as well?
Yeah, good question. I mean, you want it wherever the information is being presented. So typically you see a copyright notice at the bottom of the website, and that would cover everything. The really critical portion though is that you're registering what's actually on the blog. And you can register significant volumes of work, so if you're creating a ton of content, you don't need to go and submit a registration or application for every blog post. Submit 100 of them at a time.
Yeah. And when you do that for clients, do you recommend like every 6 months, every year? kind of what frequency are you typically doing, or is it content dependent?
It's content dependent. So, I mean, some of our clients are putting out, 30,000 articles a year, and some of them are putting out 50. It just depends on the context. It also depends on how worried you are about infringement. We have a client who puts out a ton of articles who's like, I don't really care if anybody takes these. Okay. Then they don't register anything. So, very context dependent. Good question.
Yeah, I guess how much should people budget for, like, if they're coming up with a name for a startup, if they want to do it right, like, do you or get another, what would you say someone should budget to do, like, trademarking or whatever, especially if they want to do it with their
Good question. So we have, probably close, I'm not connected to the internet. We have probably close to, 800 marks under management. I typically quote around $1,500 to get the knockout search completed, to do the strategy for the application, and to file the application. Now, what I wanted to show you, which I can't, is sort of the timeline tree of a trademark prosecution. And so at about the 6 to 8 month mark now, used to be about 3 months, you'll receive notice back from the Patent and Trademark Office, and typically what's called an office action. And those office actions are asking for more information. And it can be something really quick and easy, like you need to disclaim restaurant and bar. Okay, we disclaimed it, done. Your application proceeds to publication. If you get a more substantive rejection, like a 2D rejection for likelihood of confusion, then you might need to argue that it's not confusingly similar to that mark for X, Y, and Z reasons, and that can entail a lot more cost. So that front end work in putting in the strategy to avoid a rejection further down the line is really valuable. So I'd say typically around $1,500 to do kind of the diligence, develop a strategy, file a mark, but that doesn't mean you won't get a subsequent rejection, which would then be dealt with on kind of an ad hoc basis.
And just to be clear, what does that include? Let's say people are building, tech apps or whatever, so the trademark, the logo or the name is one thing, but as far as whatever technology they build, whether it's an algorithm, whether it's software, that's separate, right? So it's
Right.
Okay.
So the code would really be protected likely by copyright, maybe by trademark, but that's getting fairly questionable at this point. Software trademarks are very hard to procure.
So if my memory serves me correct, there's an expiration on a trademark. After a while, do you have to then re-up the renewal of that trademark, and then what happens?
Yeah, good question. So you have what's called you have 2 filings. The first filing is between the 5th and 6th year. And there's a Section 8 maintenance filing and a Section 15 declaration of incontestability. I think it's like $500 total. And then after that, you have a filing between around the 10th year, and then it's kind of every cyclical throughout that. If you don't pay those maintenance fees, then you abandon the mark, and somebody else can slide into the register and register them.
And so if you do abandon the mark, which I believe I've done, do I have to start all over again, or?
Good question. There's a grace period of a couple months after you've abandoned.
Beyond the grace period?
Yeah,
Okay.
you gotta start over. Now, you can claim priority back to the prior date, which would mean that you might be a senior user. However, when the Patent and Trademark Office reviews that application, they're gonna review them in the order that they're received, and they're not gonna really care that your rights might be senior, and you would have to essentially move against the party who may have filed that mark after you, if you were the senior user, to get around them.
Okay.
And this relates very much to that Google search as well. Like if you find something on Google that is your name, but there's no trademark application, you very well might still consider filing the trademark application, because that's going to give you a lot of leverage when they come and say, oh, you can't be that. You're going to say, oh, I have a trademark registration. They can't jump in front of you based on the fact that they're older. They would have to sue you. So there's a lot of leverage there. But short answer, you got to start over.
Okay, thank you.
To kind of follow up on this, if you go to the trademark site and you see a dead mark, is that just kind of open and you can file on that?
So the short answer is yes. The more nuanced answer is, one of my mentors told me dead men tell stories. Dead marks often are dead for a reason. And many times that's because you can tell from the prosecution history, I wish I could, sorry I'm not connected to the internet, but you can pull up the prosecution history of any mark, and you'll see what it looked like when they filed it, what the examining attorney might have said in relation to that mark, and you can see why it's dead. And maybe it's just dead because people didn't maintain it, but there's a lot of marks that are dead because somebody else came and said, you need to abandon this or I'm going to sue you. And so getting that context is really important. So yes, but there might be some other backstory there as to why the mark is dead.
And if you do look up and you see a mark there that you want, are you SOL, or are you kind of, is that the time to call you or somebody else and just see what you can do about doing some nuance on that mark?
Yeah, this is a chess game. I love trademark work because it's like, it entails a significant amount of creativity. So, for example, we represent a restaurant and bar that has the name of a certain botanical. There's a alcohol company that registered a name of a certain botanical. Technically, that is a descriptive aspect of their alcohol. So we approached them and said, let's get a consent agreement in place where you allow our mark to register, and we won't petition to cancel your mark because it's actually descriptive and you didn't disclose that. So there's a lot of ways to be creative and try to get things done. Any other questions?
Yeah, what if a company's name that they've been using for a while is a total description of the market that they're in? Say it's like a Cool Rentals or something like that, and they rent air conditioners.
Yeah.
But the name is actually kind of general as far as where do they lie as far as?
Okay, so
Actually,
if the name is generic, it's never protectable. But that would be something that is like incredibly descriptive. Seminar host or something like that. Otherwise, like the Patent and Trademark Office will vacillate towards saying that your mark is descriptive. If it's descriptive, when you first apply, you'll get what's called a 2E1 rejection for being merely descriptive. At that point, you can put the mark on what's called the supplemental register instead of the principal register. The supplemental register, a trademark serves as a sword and a shield. The shield being nobody can tell you not to use the name. The sword being you can go after other people who are using your name. If you're on the supplemental register, it's just the shield. So nobody can come and tell you it's not your name. Now, during this period of time when you're on the supplemental register, you want to be developing what's called secondary meaning. I mentioned this with chapstick. So you're going to be putting a bunch of money into advertising. You want look for ads, look for the intel inside. We do a lot of this work to help develop secondary meaning. You want to show kind of advertising spend. You want to be pointing the consumer to that particular thing. And then when you're filing an application, you can also claim secondary meaning under what's Section 2F of the Lanham Act, where you basically say the public has come to recognize this as indicative of the origin of goods. So even though it's descriptive, everybody knows that chapstick is a brand. And you prove that essentially with third-party media mentions, unsolicited especially, reviews, consumer reviews. And this has become much easier in the age of the internet because everybody's posting something on Yelp. And those reviews don't need to be good. They can say, Cool Rentals is terrible, but as long as they're recognizing that Cool Rentals is the brand name, that's showing that the general public associates that mark with the good. Other things to consider are advertising spend. And basically you're just trying to establish that the public recognizes this mark as something beyond descriptive.
And does logo help, because they've had a logo for quite a while?
Yeah, so the logo
Thinking of.
is gonna push it more on the arbitrary fanciful side, and maybe you have to disclaim the words, but you can still register the logo with the words. Adding a tagline too, maybe once again you have to disclaim Cool Rentals, but like best in the West or something like that. Could be the tagline that can be more protectable. So there's a lot of strategy in terms of what you're trying to register, and I would say in most cases, we end up filing on more than one lot for it. Any other questions? Awesome. Well, contact info is there, and I got cards up here. And if you need anything, don't hesitate to reach out. Thank you guys for coming and joining me early in the morning.